Hi, this is Mike Young, your estate planning and Medi-Cal attorney in Walnut Creek, California. And I'm going to answer one of the most commonly asked questions I get about Medi-Cal, and that is, can I have a home and still qualify for Medi-Cal? And the answer to that question is yes, but I need to explain more. So in the meantime, click the subscribe button below so that you will be alerted as to my future YouTube videos. Also check the box that you like this YouTube video. So the easiest way to make your home is exempt as an asset for qualification for Medi-Cal, meaning that the state will not count your home as an asset, is to have a subjective intent in writing. So this is a typical document I have my clients sign as part of their estate planning documents. And it is entitled Declaration of Intent to Return Home. So here is my client, Bob Doe, and he declares that he lives in his home at 123 Sharp Street, Walnut Creek, California, and I include the assessor's parcel number for identification purposes. And then Bob says, here's his subjective intent in writing. I intend, continue to intend, and have always intended to live in my residence as identified above or another resident's property, which is my home, and will continue to do so for as long as my health permits me to do so. It is also my intent and desire to return home to my principal residence, even though it may be necessary to obtain services in a skilled nursing facility on a temporary basis. No matter what the length of my confinement in a skilled nursing facility, it will always be my intent to return to my principal residence. So Bob signs this, it's dated, and as of this moment, the home is exempt as an asset for qualification for Medi-Cal. So if we are going to apply for Medi-Cal for Bob, his home is exempt, but we always check the box on the Medi-Cal application that you intend to return home. Once you check that box that you intend to return home on the Medi-Cal application, as of that moment in time, the home is exempt as an asset. When you execute this document in my office, the home is exempt as an asset for qualification as of that moment. And it's good to do this ahead because we may need to do something with the title, and we just cover ourselves better if we execute this document early on. In addition, there are other ways to make the home exempt as an asset for qualification for Medi-Cal. So the home is exempt if your spouse or a child under the age of 21 continues to reside in the home. So we would have to establish that with the Medi-Cal eligibility person. Also, your home is exempt if it is inhabited by the applicant's sibling, son, or daughter who have resided there continuously for at least a year prior to the date the applicant entered the nursing home. In addition, the home can be shown to be exempt if there are legal obstacles preventing the sale of the property, and the applicant provides evidence of attempt to overcome the obstacles, like several people have an interest in the home, one of them won't agree to it, or you can't sell the property. But why go through all that? All you have to do is sign the document, subjective intent in writing to return home. Also, if the home is a multiple dwelling unit, like a fourplex, and one of them is occupied by the residents, then the whole building is exempt as an asset for qualification. Now, the laws in this regard can may change. So there's a bill in the state legislature which says something to the effect, it's not passed yet, but it says something to the effect that if there is more than $750,000 equitable value in the property, then you cannot exempt the property as an asset for qualification for Medi-Cal. So in anticipation of that bill being passed, I have language coordinated between the revocable living trust and the financial durable power of attorney to correct that issue. So as long as my clients have good mental capacity, they can execute any documents. If they lose capacity, then I have provisions in the documents to let their fiduciary handle this. Maybe we want to bifurcate interests, transfer a percentage interest to several children, which would lower the value of the property. Maybe we want to do something else. Maybe we want to remove the home from the trust. As long as my clients have good mental capacity, then that's not going to be an issue. If they lose capacity, then I need language coordinated between the revocable living trust and the financial durable power of attorney to move the home. So why would we want to do that? And that has to do with recovery against the property. And I'll go into that in another YouTube video. So the laws could change. So you want to make sure that your elder law attorney includes language coordinated between the revocable living trust and the financial durable power of attorney to make sure that we can always exempt the home. Now, the other side of the coin with regard to the home is, how do we protect the home from Medi-Cal recovery? So if you die after having been on Medi-Cal, the home is going to want to recover against your assets. So that is another issue, another subject that I will recover, or that I will talk about in another YouTube video. So my name is Mike Young, estate planning and asset protection attorney in Walnut Creek. My website is walnutcreekelderlaw.com. If you want to check that out for more information. You can call me at 925-256-0298 or email to me at lawyoung1@gmail.com. So don't forget to click the subscribe button and the like button below, and thank you for watching.